Welcoming everyone. Good morning. Thank you all for participating. I want to particularly thank the three municipal associations for co-sponsoring this training. I know they and certainly NYMER, we strive to provide as much useful education and training that will enable our members to perform effectively and efficiently, and in NYMER's case, at the same time reducing incidents of exposure to claims and lawsuits that can impact our program, impact our member municipalities, and most importantly, I think the individuals who are involved in providing the essential services that the public comes to expect and depend upon. So we have an outstanding panel this morning. I thank them all for participating with us. I urge everyone to follow up with questions to NYMER, to your local broker if it's insurance related, and to our municipal association sponsors. And with that, David, I'll turn it back over to you and let you introduce presenters and explain how we are going to proceed this morning with the topics we'd like to cover.
Okay, thank you, Kevin. Good morning and welcome, everyone. Recent events, between police and the public have lent tremendous momentum to efforts at overhauling police accountability when using force to control or apprehend suspects. New York State moved swiftly to enact broad-based legislation to define prohibited police practices such as chokeholds and establish a variety of laws designed to improve policing in our state. A particular concern for many here today is the repeal of Article 58 of the Civil Rights Law, which guarded against the release of an officer's personnel and disciplinary records. We'll spend some time discussing use of force, the vital importance of training to your agency's use of force policy, and the responsibility that supervisors have in ensuring adherence to high standards of conduct. Admittedly, the background of the discussion is a bit onerous, with the legislation having pretty sweeping effect and having taken place quite quickly. The good news is that policing in New York State has consistently been at a high standard, unlike what we've seen in some of these events that have been broadcast on the nightly news. The current climate makes it clear that the safety of our officers is every bit as of concern as the public's trust in fair and unbiased treatment by police. Most of us are here today because of the abhorrent behavior occurring around the country, which none of us wants to see here in New York. That goes both for acts perpetrated by bad cops, but also by those seeking to harm our police in the legitimate conduct of their duties. We hope you come away with a greater understanding of how to enhance the likelihood of positive outcomes in encounters between the public and New York State law enforcement. So at this point, I'm going to introduce today's panel. John Mancini is counsel for the New York Council of Mayors. John's going to review the recently passed legislation and provide some perspective on its potential effects on police and municipalities. We're going to move then to Wayne County Sheriff Barry Virts, who is currently Vice Chair of the New York State Sheriff's Association's Executive Committee and has served as President of the association during the year 2018. He's also a member of the DCJS Accreditation Council. Barry will review use of force issues, particularly as they relate to the recently released 8 Can't Wait study. From Westchester County, from the village of Rybrook, we have Police Chief Greg Austin, who is also one of the 17 members of the Accreditation Council, all of whom, by the way, are appointed by the governor. Chief Austin will discuss the role of the DCJS in assisting police agencies in adapting to the new legislative requirements and offer his thoughts on the training which may make a difference. Batting cleanup, we'll have Attorney Greg Johnson of the law firm Johnson & Laws. Greg specializes in civil rights matters and regularly defends police at trial. He's going to speak on some of the scenarios that are likely to play out in both claims that are filed and in court. So we're now going to turn to John. John, welcome, and take it away.
Great. Thank you, David. Thank you, Kevin, and the NYMER team for inviting me to participate today, and also to my colleagues and co-presenters, Sheriff Chief, and Greg. Nice co-presenting with you this morning. What they asked me to do today is basically give a snapshot overview of the recently enacted police legislation that the legislature and Governor Cuomo signed into law. And then I'm going to focus at the very end, very briefly, on the governor's executive order requiring local police agencies to, quote, reinvent and modernize their police strategies and programs, and go over a little bit about that, which wasn't done through legislation, but through an executive order. So as of this morning, there were 10 new police bills that have been enacted into law, not all of them effective yet, which are going to, several of them are going to probably have a rather direct impact on your municipal police agencies, whether it's your county, city, village, or town police agency. There's some new rules that are going to be coming into play that certainly you're going to want to be aware of. And anyone who's on the call, we don't have enough time to go into every single one of these new bills in great detail. But if you contact me or your respective association, my colleagues over at the Association of Towns, over at the Association of Counties, I know they're watching these developments very closely, as we are at NICOM, and we can provide you with the actual text of the legislation. If there's something you want to go into a little bit more, be happy to help you with that. But I wanted to start with, and David mentioned it, the repeal of Civil Rights Law 50A has garnered a lot of attention in the media. That is the provision which historically has shielded or prevented some police disciplinary records from being released to the general public. Not going to go into a lot of detail there on this today, because from a liability standpoint, I think there's some other pieces of legislation that are probably going to have a bigger impact on the insurance side, potential liability side than that. But I will mention is that if your municipality does get a FOIL request for police personnel records, specifically disciplinary in nature, 50A has been repealed, and that took effect immediately. So this is now the law. There are some caveats contained within that. You would treat that as a general rule as you would any other FOIL request that comes in. Certain information is not going to be releasable. Personal identifiers such as social security numbers, home telephone numbers, personal email addresses. And an interesting point that a lot of folks, I think, have correctly sort of honed in on is the piece where technical infractions, a technical infraction does not need to be released under the new law. The issue is it's not defined, okay? It gives some general guidance as to what constitutes a technical direct infraction, such as it does not involve a member of the public. So I'm sure there's going to be some discussion, probably, hopefully, some guidance that is going to come out as to what the legislature has ultimately interprets as a technical infraction. So that's 50A. The next piece of law or bill that I want to just mention is Chapter 94 of the laws of 2020, and that is the new ban on chokeholds, and that took effect immediately as well. That is currently the law of the state of New York, whereas if a police officer causes serious physical injury or death as a result of a chokehold maneuver, there is the potential liability there that the officer could be charged up to a Class C felony. And so all of our agencies are going to want to be aware of that. And I know the state, as well as our local chiefs and sheriffs, are going to be making sure all of our officers who are subject to those new rules are aware of that. But again, that took effect immediately upon the governor signing it. The other bill I want to mention is the public right to record police. That's Chapter 100 of the laws of 2020. This has not yet taken effect. This takes effect approximately on mid-July, around the 14th of July, which basically is going to allow someone who is not in custody to legally and have the right to record police activities and also maintain custody of that recording. So that's a new law as well, the right of the public to record police activities. The next bill I want to mention, which is effective immediate, is in effect today, is the medical attention response requirement. I know Greg is going to talk a little bit more about this. From my perspective anyway, I think this new law is one of the bills where there could present potentially the largest exposure rate for our local governments, especially our police departments. And more or less what this is going to create, and I don't want to steal Greg's thunder because he's going to go in a little bit more, is more or less a duty of care standard on our local police officers, meaning that if you have a detainee, an arrestee in your custody, and they're in need of some type of medical attention, they're claiming they can't breathe, they're injured, maybe have some type of mental health illness, there is now a duty to act and to provide that individual with medical attention in that regard. And failure to act directly within the law, failure to act could expose the individual, the officer, the representative, or the entity, the municipality, with potential liability. So I think this is one we're going to want to follow and watch very closely. And again, that's Chapter 103 of the laws of 2020. And I certainly would encourage you to get a copy of that particular bill and review it closely with your police department as well as your municipal attorneys. Another law is the discharge of a firearm law. It's Chapter 101, the laws of 2020. This takes effect on the 90th day after it was signed, which my estimate takes us to about mid-September. And what this new law is going to require on officers is that if they discharge their firearm and it is possible that a person could be hit with a bullet, then there is now going to be an affirmative obligation on the officer who discharged their weapon to report that discharge within 6 hours to their supervisor, within 6 hours for verbal notification. And then there is a requirement for a written report. A written report must be submitted within 48 hours. So again, there are some new obligations and requirements in the event that there is a firearm or weapon discharge and the potential for a person could be hit. So you want to be aware of that. State police body cameras, not going to go into too much detail there, except that by next year, under the law, state police, New York State Police will be required to wear body cameras, as many local jurisdictions are already doing. Another one that's garnered some attention, a new law, is the Office of Special Investigation, Special Prosecutor, if you will, in the Office of the New York State Attorney General's Office. And this is going to take effect on April 1st of 2020. This creates a brand new unit within the Attorney General's Office, which will have investigatory and criminal jurisdiction where there is a death of a person caused by a police or a corrections officer. And so that special unit will have the authority to investigate and then make a determination whether or not the police officer should be prosecuted. Regardless of whether or not charges are brought, this new unit is going to be required to prepare a report which will be available to the public in that regard. So that's a brand new unit within the AG's office. The next law that has been enacted is a false reporting law. Basically is you could expose yourself, an individual can expose themselves to potential civil action if they report a non-emergency incident involving a member of a protected class. So a 911 call of which there is not an imminent emergency. So some protections there. Another unit that is being created or will be created effective, I believe, next year will be a misconduct investigative unit in the Attorney General's office. This will be a brand new position in which they will have the authority to receive complaints of alleged police misconduct. And an interesting point in the law that I don't think has garnered a lot of attention yet, but this is definitely a bill. It's Chapter 104 of the laws of 2020, and I can get copies of any of these bills to anyone who's interested. My email is jmancini, M-A-N-C-I-N-I, @nicom.org, is that if there is an officer that receives 5 complaints from 5 or more individuals relating to at least 5 separate incidences, don't try to repeat that too quickly, there will be an obligation of the police agency to report that individual for investigation to this new Attorney General's office. So that if there's an officer who receives multiple complaints on multiple incidences, that is now going to have to go under certain circumstances to this new AG's unit for investigation, for review. So again, brand new stuff. Bill number 10, policing reporting statistics. Some call it the STAT Act, Chapter 102. Basically, there's going to be more record keeping, more collection of data that will be reported as it relates to certain police actions. And that takes effect on the 180th day after it becomes law. So those very quick overview snapshot of the 10 bills that are now have been enacted. Some taken effect immediately, are in effect now. Others in the next couple of months will become there. As I understand it, the legislature, at least for the time being, has adjourned. However, we are expecting them to come back into session at some point this summer, potentially mid to late July. It would not surprise me if additional legislation is acted upon. And of course, NYMER, Association of Towns, Counties, and NICOM will keep our membership apprised of any developments as they do develop. The last point I want to make before turning it over to my colleagues is a brand new executive order that was issued by Governor Cuomo just a few weeks ago, Executive Order 203, which, as I mentioned in my introduction, the Reinvention and Modernization of Police Strategies program. This is going, or this will and has put an affirmative obligation on any local government that has a local police department. You are now going to be mandated to develop a plan that, quote, reinvents, modernizes police strategies and programs based on community input. And so local governments with police departments are going to be required to have meetings of the public to discuss issues as it relates to policies, procedures, practices of your local police department, and specifically addressing, but not limited to, the use of force. What's important to note here is these plans have to be completed by April 1st of 2020 and certified to the state of New York, to the director of the Division of Budget, if you want to receive, but the potential for any state funding in the future. That's sort of the hook on here to get people to act, is that there is potential state funding at risk if a local government with a police agency does not complete this plan and certify that to the state. It's my understanding that the Division of Budget, as well as the Division of Criminal Justice Services, DCJS, will be putting out some guidance, hopefully sooner than later, so that our local governments can get working on these plans as expeditiously as they can. So, David, that's a real quick overview, and turn it over to my colleagues.
Comprehensive too. So thank you, John.
Thank you.
We're going to move next to, and we may come back to you, John, with some questions as things move along.
Yeah, that's April 1, 2021, right? 2021?
Correct.
For the
April
plans,
1st,
yeah.
April 1st, 2021, correct.
I'm just going to mention we are getting a few questions, and we're going to hold those for a little bit. Those that I've seen are points that we will be addressing during this webinar. At this point, I'd like to move on to Sheriff Barry Virts. Barry's going to talk about some of the use of force, as it applies under this law, and also a recent study called 8 Can't Wait that proposed tenets that can be included in use of force policies, which they showed measurable results in decreasing the number of deaths when the public encounters police. So Sheriff Virts, if you would please.
Thank you, David. And I'll just start to say that Chief Austin is the acting chair of the New York State DCJS Accreditation Council. And if anyone on this program, as I am and as Chief Austin is, our agencies are accredited. I don't have a lot of worries. There's some things we're going to have to zig and zag with, but DCJS will come out with standards that we'll meet. and I think we'll be in good shape. So I'm sure the chief will talk about, accreditation, how important that is. But on June 3rd, a website popped up, 8 Can't Wait, and on June 4th, I started getting several inquiries in regards to 8 Can't Wait. And it didn't refer to the website 8 Can't Wait, but it had these 8 issues that they believe is causing a lot of police violence across the country. I can just say that New York State, and if you're an accredited agency, we have addressed almost all of these things. And 8 Can't Wait came out of a study, I believe back after Ferguson happened, from Zero Campaign in regards to what they perceive as police violence. So 8 Can't Wait wants a ban on chokeholds and strangulations, which New York State has done, and if you were accredited, haven't done that for years. Required de-escalation. I know in our area, I'm also the chair of the Finger Lakes Law Enforcement Academy, which covers Cayuga, Wayne, Seneca, Ontario, Livingston, and Yates counties. We haven't taught, chokeholds or anything like that since our 2017 academy. Requires de-escalation training, which we do in regards to our use of force annual training. I can say we could up our game with that. All police agencies and law enforcement agencies could do better with our training and de-escalation. 8 Can't Wait wants to require warning before shooting. That's how we train. We warn before shooting, but sometimes the timeliness or the situation doesn't give our deputy sheriffs, troopers, or police officers across New York State the time to warn before shooting. So that's a situational thing. 8 Can't Wait also calls for exhausting all means of before shooting. Obviously, that's the law in New York State, the use of force in the continuum. We have to do that. A duty to intervene. I believe that I know here at the sheriff's office, we have a duty to intervene if someone is medically or mentally compromised. Again, if you're accredited, you'll take care of that through your accreditation. Ban shooting at moving vehicles. I know our rules and regulations. We do not shoot at moving vehicles unless that moving vehicle is used as a deadly instrument against law enforcement or another individual. Requires a use of force continuum. Again, if you're an accredited agency in New York State, you have that use of force continuum, and we are mandated to train on that annually, our use of force policies. And then again, it requires comprehensive reporting, which again, accreditation takes care of all that. We did have several rallies here in Wayne County. And again, I'll just picture what Wayne County is. We're a rural county of about 90,000 people. We sit in between Rochester and Syracuse. Where I live in the county, 45 minutes to Rochester, 45 minutes to Syracuse. We're more of a bedroom community to the Monroe County, the city of Rochester, the greater Rochester area. Well, that's a bad thing in a way, because when we do grants, we're considered an urban area because we're a bedroom community there. But we've had 4 protests in the county, all very peaceful. The protesters got in touch with me, told me what they were going to do. I spoke at every one of them. But I think that one thing that all law enforcement agencies, how we can up our game and do better, is annually we should mandate implicit bias training. We should mandate racial bias training, and also we should enhance our de-escalation techniques. And I'm one to advocate for body cameras and car cameras. We went to body cameras in 2018. I studied the Ferguson incident, read everything I could read about Ferguson and everything that happened there, and a firm believer that body cameras de-escalate the situation. I know our personnel complaints have dropped by 90%. We invite people in to look at the camera video after we've concluded our personnel investigations. But again, it gives a snapshot. It's not the fix-all, but it does give a snapshot in the tone and the tenor of the incident from a perspective rather than different snippets and clips or videos of other people. It puts the event in a sequence from the law enforcement officer's perspective. Anything else you want me to cover, David?
Barry, 8 Can't Wait kind of echoes what you're hearing in the news too, with calls among the public to divest from police funding and reapportion those funds to community outreach. And what I was wondering is that something that you see likely to affect law enforcement here in New York? And if it does, is it going to provide kind of a different method of addressing encounters with the mentally ill or in domestic situations and other situations similar to that?
I'll just say, from a sheriff's office perspective, because I have to run a jail also. A police department doesn't have to run a jail. So, on one side of the coin, we're arresting people. Our deputy sheriffs out on the street are arresting people. And then when they are placed in jail, so I have two social workers, I have two CASACs, and I have a case manager for people that are incarcerated. I also have a contract, and we work with a pretrial agency here in the county. I sit on their board for the last 20 years. Every individual that's brought into our booking area, they have contact with that individual to do pretrial supervision. So we've been even though we're a rural county of 90,000 people, I have been very aggressive to provide services. Part of my career, I spent 10 years from 1999 to 2009 running the jail facility. So again, being a small community, we really intimately know our members of our community to provide services to them, have a great connection with mental health. I think law enforcement all across the state should reach out to their mental health providers in their communities to get to know them, to refer people to, or if there's de-escalation, to have them come in and talk to the officers. What else could I add? I don't know. What other question might you have, David?
Well, police are having a rough time right now, obviously. And there is a sense in some cases that they're under siege. We saw in Buffalo how the members of the emergency response team responded by resigning from that. And with respect to the duty to intervene, what kind of training and supervisory methods might be used to just sort of overcome that resistance that some see as that thin blue line, which we know has been in retreat for some time, but is still apparent on the news and such?
Well, I would just say, again, through accreditation, through your general orders and policies of, the police department or the sheriff's office that someone oversees here, annual training, we have to do first aid training manually. I'm somewhat concerned with what is going to be the level that is expected of how we're going to have to intervene. But again, it just comes down to being a human being. If someone needs care, that you provide that care. I think that, in the George Floyd incident in Minneapolis, we went through that in New York State with Eric Gardner. I think everyone in New York State and law enforcement knows that, hog-tying went out years ago to do that. When you have an individual on their stomach to breathe, and especially an individual that's distressed and in restraints, you go from lung breathing to diaphragm breathing, okay? And that puts more stress. So again, in that situation, one of those four officers should have had the leadership to say, look, he's in distress breathing, he's handcuffed, we need to roll him over. If you have to hold the head, have to hold the shoulders, have to hold the feet, but you need to get them off of their chest. Again, because it goes from lung breathing to diaphragm breathing, which can cause, a lot of bad incidents, which it did in Minneapolis. So again, we've been trained to do that. And again, what I do is, and I'm sure Chief Austin does the same thing, even though we're accredited, we see through Twitter and other places in the news. I look at, when I see stuff across the country, I look at it to say, hey, we're prepared to handle that. Or I might see something to say, hey, I didn't see that coming. We need to get ready for that. Need more training. So again, it's constantly evaluating what's happening around the country, what's happening around the state, and with the resources that you have, to do the best you can to give the resources to your officers to train them to be prepared to serve the public.
So training in recognizing when someone is in physical distress, how to best restrain and control a suspect or a detainee, and recognizing when somebody might be endangering them and intervening to correct that situation.
Yeah, and again, I think the biggest thing for de-escalation is for officers to understand, those that might exhibit, mental illness. Chief Austin and I, we're not qualified healthcare professionals or mental health professionals, but we've been professional voyeurs our entire life to see, people's different actions. We can't tell you what that actual excess diagnosis is. There's about 700 plus of those, but we can tell when something's off and that we need to intervene. We've trained many of our deputies in CIT training. The mental health first aid for law enforcement is an 8-hour course. We put all our corrections officers and all our deputy sheriffs through that. We do that every other year to keep that updated. Have many of our officers trained in CIT training. Matter of fact, we're looking at a project where we've had 4 iPads. So when a deputy goes to a situation where there's mental health issues, we can put that person on the iPad, connect them to a mental health professional at our Wayne Behavioral Health Center, and they can talk directly, to that individual. That's been so successful. And since we're a take-home car program and we don't have a roll call, we're going to get every deputy sheriff a smartphone. So every deputy sheriff has the ability to make that connection, because even in this county, our site cases, our site calls have gone up drastically since COVID-19. Drastically. We're doing 35 a week. That's huge for a rural county, 35 a week.
Thank you, Sheriff Burtz. Okay, we're going to move now to Chief Austin. Chief, could you talk a little bit about how DCJS can be a resource for adapting and adjusting to the new legislative requirements?
Sure. Thank you, David, for having me on this morning, and I'm very happy to be serving on this panel. And it's always a pleasure to serve with Sheriff Burtz on the Accreditation Council. Thank you, Sheriff, for the nice things you said in your presentation. DCJS in June 2019, published a use of force model policy. And the model policy was based on the law that was signed by Governor Cuomo in April of 2019. What DCJS is doing, and for accredited agencies, is really put us ahead of the curve and ahead of what is happening elsewhere in the country in terms of reporting and intervening and banning certain actions like the chokehold. I mean, none of us in law enforcement were ever taught to use a chokehold as a method of restraining. But what we find is that police officers over time need additional training, and police officers over time, like everyone else, become overweight, underconditioned, and often outmatched by a younger person. And what happens is if a police officer is in an altercation with someone, they're trying to arrest them or restrain them or bring them under control for some reason, and they're by themselves, and the less lethal weapons that they have, the taser or the pepper spray that they have don't work, or just for some reason weren't deployed, and now they have to use defensive tactics. Defensive tactics is a skill, and the skill has to be practiced, and a skill has to be trained. And most departments, and my department is guilty, there's also trained once or twice a year in defensive tactics. And the problem with that is, as any skill, you get rusty, and if you're not prepared, you resort to using tactics like a chokehold, or just grabbing someone by the neck and putting them down, or putting them down on their stomach and then just putting all your weight on them just to restrain them. And like the sheriff said, there has to be training now in recognizing a person who is in medical need, a person who is having difficulty breathing, because it may not be apparent initially, and when it becomes apparent, it's going to be too late. And so I think that training needs to be done. The DCJS, through the accreditation program, is preparing the departments to be ready for this. Like the sheriff said, I'm really not too concerned about what we will need to do to meet the new obligations that we put on us, because I think we are already there with most of them. I'm be honest with you, I'm excited to see what this brings for us in the next 10 months to get ready for this. I'm interested to meet with the public, to hear what they have to say, to see what they expect from us. Just recently, I had a meeting with clergy, community activists, the NAACP, just to talk about our police department. And it was a very easy meeting for me, because we talked about accreditation, we talked about what we're doing, we talked about what we're preparing. And one of the questions they asked me was, how are you going to prepare for the new obligations that will be set up for police departments in the coming year? And I was very easily just to explain what we're doing already and explain our use of force policy. One of the requirements of the DCJ is use of force policy, model policy, and the governor's law is the use of force data collection. And when this first came out, there was requirements to report when you're brandishing or discharging a firearm, but those weren't defined terms. So in December of last year, those terms were defined. DCGS has plans to put the reporting mechanism on the integrated justice portal, but it's not there yet. So they have like a survey gizmo is the tool that they're using to publish that. So, and also DCGS has a training video that they published to get police officers up to speed on the model policy. And if you haven't viewed the video, hopefully, David, I'll send you a link. If you don't have it, maybe you can send this out to everyone afterwards. I recommend everyone to view the video. I reviewed it yesterday just to get myself ready for today's presentation, and it's an excellent video. Mark Swan, who's part of New York State Association of Chiefs of Police, he's a former director of training for us, and now he's just recently has come back to NYSACOP to get involved in different part of our training needs. He's the person who presented it. You know, I recommend watching that. You know, things that I think we need to have ready and that DCGS has mandated is an investigation of use of force incidents. I mean, vital that there's a swift, comprehensive investigation for public transparency, but also for the police officer. A police officer doesn't want something like this hanging over their head for weeks or months, not knowing what's going to happen. So you have to have that done quickly. And you know, and then if something ever goes to trial, you have an unfiltered, objective listing of all the evidence that was done to be presented. And the last thing I want to talk about is de-escalation. I always felt that police officers were experts in de-escalation of situations. I felt that, you know, that was probably one of the most important part of our job, was to be able to skillfully de-escalate a situation. But now we're dealing with people who are emboldened and are encouraged to challenge the police. And that has made it more difficult for us, where our de-escalation techniques from the past don't have the same effectiveness. So, you know, de-escalation is a very important tool, especially for police officers who may get into situations with the public that are where the public is looking to push the envelope and to see how far they can push a police officer, especially, you know, with everyone now recording every encounter with a police officer all the time. You know, body cameras, vitally important, because you need to be able to tell your story. If someone's recording you, you should have the ability to record them, because you need to be able to tell your story. You know, and, you know, going back to defensive tactics, you know, a problem with defensive tactics training is the injury rate. I've lost 3 police officers due to shoulder injuries during our defensive tactics training. And I'm not going to stop doing the training because it's important. You know, we just have to make sure that they're properly warmed up, and officers who feel that they're not conditioned enough to participate in, at least watch it. But, you know, I think that, you know, the risk of injury during training is real, but it shouldn't be a reason to not do the training. And I think a lot of places don't do the training because they don't want to risk the injuries. But, you know, you're going to get hurt in training, or you're going to get hurt out in the street. And at least you have a better chance of not getting hurt out in the street if you train. So that's really the bulk of what I have to say, David. If there's anything else you'd like me to talk about?
Yes, Chief, could you kind of draw a picture of what community policing looks like and how it may impact relations out on the street and make perhaps those de-escalation scenarios a little less stressful?
Well, I mean, community policing is not new. It's really just knowing your community, and part of de-escalation that eases it is when there's a familiar face. You know, we always look for a familiar face in the crowd. It puts everyone at ease. And if the police officer is going to be in his car and drive around and not interact with the public on a positive basis, but only on a negative basis, then that's going to make things difficult. I mean, police officers should be involved in the community. They should get out of the car. They should walk around. They should know the businesses. They should know the kids in school. They should have good relationships with the school administrators and the school districts in the communities. They should be able to go into the school district. We, in Rybrook, we still have a DARE program. We've run a DARE program since 1994. It's still going strong. The community supports it. The school district encourages it. We feel it's very important for our police officers to be part of the DARE program. We run an officer fill program where we have a magician come into the school district, and they talk to the kindergarten through 4th grades about officer stranger danger and like that and things like that. Very, very important. I have a youth officer who serves on different community coalitions. I serve on community coalitions. Just to be involved with the public, the Rotary Club, the Lions Club, these are all things that are important. So you're a familiar face, and people know you, and you know people also, because you know, the people are, you know, we work for the public. You know, I answer to the mayor and the village board, but I truly answer to the public. You know, the public is my boss, and that's who we report to. And you know, you want to get to know your boss, so it makes sense that you want to get to know your community, and so you really should be in the community, and your police officers should be in the community also.
I know that I was speaking with, about a month ago, I can't remember the agency, but their officers were taking their bikes out on their car, and when they got to their beat, they got on their bike and rode around. I know that in many cases I've seen bikes leaning against the wall in police stations, and it seems that may have become a less active part of their routine than perhaps it could be. And do you feel that might play an active role here?
Oh, sure. I mean, we have an officer on a bicycle. He patrols the parks. You know, especially during the Little League season, which didn't occur this year. But you know, it's great for him to be out there and riding the bike through the parks, and you know, riding with the kids. We had a program a few years back where if we saw kids riding without bicycle helmets, the officers carried bicycle helmets in their cars, and they gave the kids bicycle helmets and explained to them about head injuries and why it's so important to wear a bicycle helmet. You know, and that gave the opportunity for the police officers to talk to the kids on a positive basis and give them something, and the kids enjoyed that, and it was a popular thing to do. And you know, I think a bike patrol is a very important thing. You know, Rybrook is not laid out to be a foot patrol community. We don't have a downtown area where officers can be on foot, but we do have many beautiful parks, and just like you said, we put the bicycle on the back of the police car, you park the police car, and the officer gets off and they ride on the bikes. I know there's rail trails through New York State, and where I live, there's a rail trail which I use all the time, and I always see members of the Putnam County Sheriff's Office on the rail trail riding and talking to people. It's
That's great.
really an important thing, and I think bicycle patrol is a very good thing to have.
Thank you, Chief Austin.
Thank you.
Greg Johnson. I know that a lot of this is going to come right down the alley to you in terms of fielding claims and supporting officers at trial. Perhaps you can talk a little bit about how the new legislation is likely to play out in your role.
Yeah, thanks, David. Good morning. It's a pleasure to be part of this panel. So already learned quite a bit about the training that's going on, so that's great.
Greg, do you have your phone on as well, or your computer audio too? We're getting a little feedback.
Oh, is that right? Hold on a second. Let me see if I can change that. Is that better?
Appears to be. Let's see.
Is that better?
Yes. Thank you.
Okay. So I now can't hear you, but you can hopefully hear me. So I obviously, as already mentioned, one of the big liability concerns going forward is going to be this new Section 28 of the New York State Civil Rights Law. Now, of course, before that legislation was ever passed, there was always a constitutional duty to provide a level of care, which included medical access to medical care by police. And that had been defined really at the federal level for decades. And the standard was deliberate indifference, which is a fairly well-established legal standard that probably, at least in my mind, as a defense counsel, struck an important and reasonable balance between the public interest of effectuating an arrest and the interest of a suspect or an arrestee to get access to medical care. So with that as the backdrop, I think this new legislation is definitely a shift. I think it obviously, as already mentioned, creates a statutory legal duty to provide broad spectrums of healthcare, and it places that directly on police departments and officers individually. While certainly there was a standard of care, now it's defined in a very clear and affirmative way by statute, which of course will make bringing these claims easier. This deliberate indifference standard that has been in existence for decades, of course, is now, at least at the state level and under this legislation, doesn't exist. So I think this Section 28 is going to provide an avenue for a dramatic increase in claims, because it's going to be easier, at least from my reading of the statute, obviously it's brand new, to pursue these claims under the state civil rights amendment than it would under the federal standard, because this makes no mention of deliberate indifference. And in fact, it doesn't make any mention of any kind of intent standard. Presumably it's reasonableness or good faith. And those sound like nice terms, but in the world of litigation, what that probably means is that those kinds of issues of was this in good faith or was this reasonable are going to ultimately be jury questions. So prior to this legislation, there was an opportunity to get rid of marginal claims at motion practice. And I think we're going to see that not only is there going to be an increase in claims under this state civil rights law, but you're also going to see that those litigations are going to be elongated, and they're often going to get to a jury as opposed to those marginal claims or maybe even frivolous claims being disposed of under deliberate indifference standard. That might not be available to police officers and police agencies and defense counsel like us. And then lastly, of course, the statute, as you can see, plainly provides an incentive for plaintiffs to bring these claims by providing attorney's fees to successful plaintiffs. So that's a plain statutory incentive to pursue those claims. The interesting thing I note that's what we call a fee shifting provision. That's not necessarily new. We have that in the federal civil rights system, and we have for 50 years. But usually that's drafted as a neutral statutory statement. In other words, the prevailing party. But I notice here that New York is just only the prevailing plaintiff can recover attorney's fees. So in those cases where there's a completely frivolous claim brought against a police officer or law enforcement agency, there's not going to be a reciprocal opportunity to hold irresponsible litigants accountable as there might be under the federal statute. So I guess those are my initial thoughts about this new Section 28. And I think that's what I anticipate is going to be the ripple effect. Some of the other panelists have already mentioned the repeal of 50A. In my litigation experience over the last 30 years, that's a very important provision, even if it only establishes a presumption of confidentiality with respect to personnel files for police officers. And what that usually historically has done is allowed us, if not necessarily to prevent disclosure in litigation, but at least maybe to control exposure by getting protective orders and things of that nature to ensure that police officers are not embarrassed, or that we don't have these collateral trials over what somebody allegedly did 5 years ago. So the complete repeal of that statute is obviously going to disrupt the way that in the litigation process and the discovery process, how those personnel records are going to be handled, and probably the operative presumption that I think most judges have, which is to respect that those documents need to be handled with care. Doesn't mean they don't just get disclosed, but at least they get managed in the litigation process in a responsible way. We'll have to see how judges handle that. If the repeal actually leads judges to simply say, hey, they're no longer confidential, we no longer presume that there's any special protection there. So I think that remains to be seen, and I think it's certainly cause for concern. And my experience, and this kind of dovetails with the other piece of legislation that was discussed by John concerning the reporting up to the state level when there's 5 incidents or 5 reports. Certainly for those police officers that are engaged in a pattern of excessive force, no one would begrudge that gets investigated, and I certainly wouldn't either. However, in doing this for 30 years, some of the best police officers, some of the most proactive police officers often generate those complaints as well. I mean, so, this being such a public issue, one of my concerns would be that, people are going to manipulate it. They're going to make complaints because they don't like a particular officer. I mean, people don't like to get arrested. And when police officers have to make arrests, the portion of the population that they're unfortunately dealing with are amongst oftentimes, they're the least honest, they're most manipulative, and most unpredictable. And so, I think it's going to be a challenge for supervisors and departments to manage and investigate those complaints and ensure that this doesn't become a game where a game of gotcha, where good police officers who are doing good police work and are out there doing their job are being targeted by folks who realize that we can put, a spot on that officer's career and have them investigated and turn the table, so to speak, on the officer. So I think that's going to be an issue that we need to monitor very carefully. With respect to the New Yorkers' Right to Monitor Act, obviously that reality of civilian video has been with us for the last decade already, and I think officers have already had to manage it. The interesting part about that is this language in the statute that allows or affirmatively states that the owner of the video, gets to maintain custody and control. So it'll be interesting to see how that works, because sometimes that civilian video captures criminal activity, and the officers or somebody like me defending an officer might want to obtain that video from a civilian through subpoena or other means to ensure that the real story or the best story for my officers is shown as well, because the body-worn cameras are fantastic, but oftentimes in use of force situations, they end up on the floor or they end up capturing what's happening in a ceiling. And a bystander video captures sometimes another very, very valuable perspective. So it'll be interesting to see how courts deal with that language in the statute, since obviously it's not just the news media that might be interested in those civilian videos, but it might very well be people like me and the police officers and the departments who want to capture that video in order to ensure that we have a 360 degree perspective on use of force situations. And I guess I know it's sort of beyond the ken of the state legislation, but I'm going to mention it because I think it's a big issue. But nationally, obviously, there's been a lot of discussion about the abolition of qualified immunity. And I think there's, at least from my take, there's been a tremendous amount of misinformation about how frequently police officers are able to avail themselves of qualified immunity in real life litigation. So that's a national issue. I know that's not just a New York issue, but it obviously is percolating in a lot of different forums. But that's a very limited defense that provides a very important margin of error for police officers to do their job in those split-second decisions where they have to make judgment calls in those gray areas. And so that's something also that we all need to watch very carefully and advocate for, because the truth is qualified immunity has already been profoundly narrowed for police officers. It would never be available in any of these recent incidents that we've seen on the news. Those cases are not qualified immunity cases. But if the knee-jerk reaction is to eliminate qualified immunity, I think that's going to be a profound problem for police officers, ensuring that they can do their job in those difficult situations. So I think that's another thing beyond the state legislation that we all need to pay attention to and watch carefully. Anything else you want me to address, David?
Yeah, Greg, you are able to hear me, or?
Yeah.
Okay. The repeal of 50A, what impact do you think that's going to have on jury pools? Is it a case where only those founded allegations against a police officer are disclosed, or is it founded and unfounded allegations? And, you know, if you have a police officer that's been on the job for 18 years, he may have had more encounters that were challenged than somebody on the job for 5 years. How is that likely to play out in the defense of our police officers?
Yeah. So I think starting off in the discovery phase before you get to trial, and I'll answer that question, I think obviously this is going to make it more, I'm sorry.
I didn't say anything, Greg.
Barry's raising his hand.
I just raised my hand because I want to ask a question like in class. So I'll wait till you get done.
Oh, okay. All right. So I think in the discovery process early in the first phase of litigation, it's going to be much more difficult to withhold any portion of those personnel files or those civilian complaints. Typically, in a case where there is data like that and records like that on a particular officer that are arguably relevant, we'll get a protective order that it'll be turned over, but it'll be subject to a management protocol where it can't be abused. Getting to trial, in theory, I think most judges would say that if it's not founded and it's merely a complaint, it's not evidence of anything, and generally it wouldn't come in. Now that's a simple proposition, but trial is not always like that. So it could become admissible and very prejudicial to an officer, even if it's not a founded complaint, by virtue of other things that happen at trial. So for example, let's say before the trial, the judge agrees that this is an unfounded complaint and it's not relevant, and therefore it's not admissible. But then the officer gets on and gives affirmative testimony about a particular methodology that they use or a procedure they follow. Then that record concerning even an unfounded complaint could be used for impeachment. And even though it might only be used to impeach the practice or the protocol of the officer, obviously it has a profoundly prejudicial effect on the jury hearing that there was another complaint. So I think it's going to make it significantly more difficult in discovery. And then I think when you get to the trial process, it's going to require trial counsel to think through every facet of their case to ensure that A, they keep out unfounded complaints that have no evidentiary value, but B, that they manage the whole trial presentation to ensure that they don't open the door to allow that kind of damaging information come in. So it's going to create a whole bunch of new challenges, even if unfounded complaints don't necessarily come in as a matter of course, they still can be dangerous pieces of information.
Thank you, Greg. Sheriff Hertz, you have something to add?
Yeah, just Greg, I'm glad you brought that stuff up because, you know, 50A, if it's an arbitrator's decision or a stipulation agreement or the officer pleads guilty to the internal charges, you know, obviously we understand that to be done. But when complaints are made against what you state, good officers that are complaints that are exonerated through the investigation for using proper police protocol, procedure, and techniques, or the complaint is just unfounded, we still have to turn over those complaints under that 50A new law. And that's somewhat troubling because then they're going to get on social media, they're going to be put around. Now it's going to undermine the, reputation, the professionalism, or even the command presence of a law enforcement officer in that community. So that's a pretty tough thing to swallow for law enforcement. Again, I understand the arbitration agreement, the stipulation agreement, and the plea of guilty, but officers that are exonerated or it's unfounded by using proper procedure, that's going to be tough for everybody all around. And then the other thing, for the public's right to video, we've told our deputies that, look, they do have a right, but we still have the ability to maintain a safe area of work and distance between what we're doing. It doesn't mean somebody can get right on top of us in video. We might say to someone, our traffic stop is on the south side of the road. If you want to video us, you got to go to the north side of the road, but you can't be right on top of us. And I think we're going to have some problems as we work through that until the public gets educated that, look, you can't be right on top of law enforcement.
We have a question from an attendee. If we feel the 5 complaints on separate issues are frivolous or manufactured, what liability does an agency have for not reporting to the AG? So to add to that, I guess, is there some kind of auditing process that the AG's office has telegraphed to the legal community?
I would just say, under the law as it currently stands, I did not see any type of a penalty, if you will, for failure to report. But that is not to say that there may be some regulation that comes out post once this becomes gets enacted, or they could always do an amendment to the law, and we have seen that play out in the past where something's been overlooked. These bills went through very quickly, although some of them have been around for years and in some version, but these 10 bills went through the legislature at rapid lightning speed for the New York State legislature. So there may be some unintended consequences. There may be some areas that they didn't contemplate. That's why I said this session coming up in July and post-July, we're going to be watching very closely to see if there are any updates to it. But to answer your question directly, I don't see any penalty provision as it currently stands.
Thank you, John. Another question regarding the medical attention law, where does substance abuse impairment fall? I guess that would be, how was the officer's duty to be able to recognize and adequately respond to perhaps, some borderline issue where, somebody appears to be impaired. Do you get the medical, do you ask them, do you want medical attention? If they say they don't want medical attention, do you have to verify that in some way? I know that's the case in a lot of policies where if the detainee says, no, I don't want medical attention, you need to have somebody sort of verifying that is actually what took place. So in terms of drug impairment, how would that play out?
David, I think that's one of the murky portions of this. Time will tell what happens. How do you determine an uncooperative person from a mentally ill person to a person who is under the influence? I think calling an ambulance and have them refuse medical attention covers the police officer, but a person who is ill or who is injured, that's easy to get the medical attention. But it's the person who is mentally ill. I mean, we see it all the time. We call the crisis teams. We bring people to hospitals for medical evaluations, and they're out before the paperwork's done. So I think that's going to be a very difficult part to determine of where that falls. And, I'm sure there'll be some case law on it.
Thank you, Chief. Another attendee was just looking at New York State's use of force model policy adopted in 2019. And Chief, you may want to address this. He does not see a use of force continuum in that policy. And I know you and I talked about how that's a framework rather than a fully fleshed out policy. Perhaps you could expand on that?
Well, sure. I mean, there's different types of continuum, and I think you have to adopt the one that is suitable to your department. There's different theories on it. It's it's academic, and I think New York State was wise to not pin departments down to a use of force policy, because there's different situations, and sometimes you can't go through verbal commands and less lethal commands, weapons. Sometimes you have to go right to deadly physical force depending on the situation. So I think you need to have a use of force continuum that's consistent with best practices, but that's suitable to your department and your training that you provide your officers.
So use of force continuum, and within a use of force policy typically says that you don't have to ascend strictly through the linear order of those increasing uses of force, because the situation may not allow that. You can jump up and skip a step if that's warranted by the crisis that you're facing, or you can back down as well. That's
Exactly.
more or less right? Okay.
Exactly.
Okay. Greg, I know that you have seen the use of force continuum as perhaps presenting a problem or two in its interpretation too. Or am I misspeaking there?
No, I think sometimes it's wording. I think most officers now are trained exactly as you just described, and they view the various force options as a wheel. And I'm sure the sheriff and the chief would echo that's how officers are now taught. The nomenclature, though, of a continuum, and sometimes the policy language in some departments don't match the training, and the policies could be read to require this sort of sequence, working your way up the use of force continuum, which is simply not how the real world works. Not only do you sometimes need to jump from level 2, if there is such a thing, to level 5 because of the escalation, but it could also be that you can't use OC spray because you're in a confined space with another officer, and it would compromise what you're trying to do. So that is not even part of the continuum, because it's simply not advisable to use, or because there's a combustible situation. So my only point of that I was mentioning is that the word continuum is often misunderstood, I think. And when those policies are drafted, I think it's critically important that the language in those policies don't come back to haunt departments, because I think the officers know what to do. I think the training is consistent across the state as I see it, but sometimes those policy language lags. And then I've got police officers and supervisors who are being cross-examined about policy language that would suggest that this is a rigid continuum, which of course I think is a very outdated paradigm.
Okay, thank you, Greg.
Well, just some of the tools that, law enforcement has and carries, a taser, a HASP, OC gas, handcuffs, and a firearm. And as Greg said, it's not like you go through 1 to 2 to 3 to 4 to 5. It's fluid in how that works. And I'm sure John and Greg will say every single case has its own individual facts.
Another attendee, thank you, Sheriff Burtz. Another attendee asked, doesn't duty to intervene include stopping excessive force by another officer? And the answer is, of course, yes. Does anybody want to expand on how they see that duty to intervene, placing the responsibility on officers, and perhaps address training components?
I'll be happy to make a couple comments about the liability part. I mean, and my experience with that. I think candidly, I know people refer to it as the thin blue line, but I think my experience working with police officers is there is a very necessity and legitimate sense that officers need to be able to count on each other. That doesn't mean lie for each other. It means to be able to count on each other, that you have my back, and this is not when I'm making an arrest or I'm trying to engage with a suspect that's resisting, then I've got your support. On the other hand, yeah, when that line is of the Fourth Amendment is clearly crossed, and that's again a case-specific case, the officers need to be trained that they have a constitutional obligation to intervene. And I think that's a very difficult thing for officers to do. And I think it's probably even more difficult when they have body-worn cameras, because they might be obviously creating a record of correcting or criticizing their fellow officer. My thought about, and I'm not a police officer, so it's just a thought, is maybe to train officers to substitute or take over the restraint as opposed to intervening. In other words, if my perception is that the officer is crossing the line and using a methodology that's not warranted, a level of force that's not warranted at that moment, instead of criticizing them or reprimanding them, maybe I jump in and take over the restraint and substitute for them, and that be the sort of the training point, so that people are less reticent to engage in behavior that their fellow officer might think is not supporting them. So that's a very fine line, but certainly we see a lot of failure to intervene claims to officers that, realistically had no opportunity in terms of time, space, or authority to do anything, but those are very prevalent, and they're becoming more prevalent. And I think with the way that the cultural dialogue is going on, we're going to see even more of those failure to intervene claims. So the plume of litigation, instead of just being against Officer A and the department, it's going to be against Officer A, B, C, D, and E.
David, I also think that officers intervene all the time. It's just not really apparent because it's only the extreme cases that get publicized. The intervening is getting advice from another officer, bouncing something off them when you're on a call, or getting guidance, or sometimes an officer who's dealing with an uncooperative person is not getting anywhere. Another officer steps in, just like Mr. Johnson said, and takes over because maybe they have a better rapport with that person. I mean, that's intervening. That happens all the time, but it's just part of our job and it's part of our police work. People just don't realize it. And it's those extreme cases that get brought out, that get publicized. But that's part of police work, is officers working together to fix the problem. Problem one in policing is what we do is to look at each call as a problem and how to solve that problem. And our job is to get the job done.
Thank you. Seems that most of the better policies I read also state that if an officer sees inappropriate behavior being conducted by another officer, that they have a positive duty to report it. In other words, report it to the supervisor. Does that have any implications for disclosure now that 50A has been repealed, or any such thing as that, or is that more of a technical internal matter?
Well, I think that's going to, make it easier for an officer, because now that the burden's on them to say something where they maybe in the past wouldn't, because they don't want to get their coworker in trouble. But survival of the fittest. They have to watch out for themselves. They may say something now because now it's now they could get in trouble for not saying something.
So the other thing too is I think it's going to be more supervisory accountability. Line sergeants, lieutenants, depending on how big or small your organization is. We say that if we have, several cars, that we require a sergeant to go to that scene. And again, as you said, Chief Austin, the officer that may have had the conflict or the physical conflict to get the restraints on the individual handcuffs, once another officer gets there to separate those two for that other officer, as Greg said, to take over that individual, the care and custody of that individual, to allow the other one to go write his report to kind of diffuse the situation is important.
Another attendee question: what is the application of the new of the repeal of 50A legislation on a case that's currently in litigation?
50A took effect immediately, and I know there was some questions when it first got passed. There is no retroactivity component to that law. So if you have the record, you've got to treat it as a FOIL request or as a releasable document if it's so inclined.
Thank you, John. How far back can personnel files be foiled, and does it include retired officers?
as it relates to the FOIL aspect of it, is one, most local governments follow the MU1 record retention schedule. And so you would treat those documents as any other municipal record that you have. And to the extent, if it's eligible for disposal under the MU1 legally, then whoever the records access officer should be going through routinely inspecting all records, not just personnel in nature. But again, if a FOIL request comes in and it is a public record and it is releasable, meaning there are none of the standard provisions why a particular document would not be releasable, personal information, invasion of personal privacy, those sorts of things, then it would be a releasable document. Again, there is no retroactive aspect of the 50A repeal as it currently stands.
The other thing too is, as you mentioned, John, if you could have disposed of a record and you didn't, and you get a FOIL request, you need to release that record. You can't just say, "Oh, I should have disposed of this. Now I'm gonna, since I got this FOIL." That's going to get you in trouble too.
Absolutely, Sheriff. Excellent point.
Thank you very much. Well, we've pretty much run through the questions from the audience, and I know that we do have one or two insurance-related questions, which we can get back on outside this forum. And we do have a poll, a quick 3-question poll that we're going to try to launch here. I want to thank everybody who took part in this. Thank our panelists. I think you all did a great job, and I think we've all come out with a better understanding of the legislation and its implications. So, Karen, if I'm going to try to launch this poll, I may need an assist from you. We'll see. Okay. But thank you very much, everyone. And if, okay, yes, okay. The poll is being launched. So if you can just stick around for those 3 or 4 questions, I'd very much appreciate it. And thank you again, everyone. Thank you.
Thank you.
Thank you.
Thank you.
Oh, we can't vote.